Massachusetts has one of the most tenant-protective breaking lease frameworks in the entire country, shaped by the state's powerful consumer protection statute, strong implied warranty of habitability, and an enforcement culture that aggressively pursues landlords who violate tenant rights. The governing law includes Massachusetts General Laws, Chapter 186, the Landlord-Tenant Chapter, Chapter 93A, the Consumer Protection Statute, and General Contract Principles. If you're a landlord or tenant in Massachusetts, the breaking lease framework heavily favors tenants, and the financial consequences of landlord noncompliance are severe. Let's start with the landlord's duty to mitigate damages. Massachusetts has one of the strongest and most clearly established mitigation duties in the country. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. This duty was firmly established by the Massachusetts Supreme Judicial Court and is consistently enforced by lower courts. The landlord must actively market the unit, advertising, showing it to prospective tenants, and accepting a qualified replacement. The landlord cannot hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. If the landlord fails to mitigate, the departing tenant's liability can be substantially reduced or eliminated. The departing tenant's liability is limited to rent during the vacancy period, while the landlord is making reasonable re-rental efforts, plus the landlord's reasonable re-rental costs. Once a replacement tenant moves in, the departing tenant's obligation ends. Massachusetts courts scrutinize landlord mitigation efforts carefully, and landlords who drag their feet or make only token efforts face unfavorable rulings. Early termination fees in Massachusetts must be reasonable and consistent with the state's consumer protection framework. Chapter 93A, Massachusetts' powerful consumer protection statute, provides a basis for challenging fees that are unfair or deceptive. Under 93A, a tenant who is charged an excessive early termination fee can recover treble damages plus attorney's fees. This creates enormous risk for landlords who impose aggressive fee provisions. A fee of 1 to 2 months' rent with reasonable notice is generally considered acceptable. Fees approaching the full remaining lease amount, or fees that don't account for the mitigation duty, are highly vulnerable to 93A challenge. Massachusetts courts have a long track record of imposing treble damages on landlords who violate 93A, and the risk of punitive liability far outweighs any fee revenue. Remember that Massachusetts prohibits landlords from charging application fees, and the only charges a landlord can collect before move-in are first month's rent, last month's rent, the security deposit limited to 1 month, and the cost of a new lock and key. This restriction on pre-tenancy charges reflects the state's overall approach of limiting landlord fees, and that philosophy carries through to the breaking lease context. Military members have the right to break a lease under the SCRA. Massachusetts's military population is moderate. Hanscom Air Force Base, the Natick Soldier Systems Center, and various reserve and guard facilities generate some military demand. The SCRA applies to any service member renting in Massachusetts. Massachusetts has enacted protections for victims of domestic violence, rape, sexual assault, and stalking that allow early lease termination. Under Massachusetts General Laws, Chapter 186, Section 24, a tenant who is a victim, or whose household member is a victim, of domestic violence, rape, sexual assault, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a valid protective order, either temporary or permanent, a record from a court documenting the abuse, or a written statement from a qualified domestic violence counselor, sexual assault counselor, or healthcare provider. The tenant must provide at least 30 days written notice, or may leave earlier if remaining poses an imminent threat to safety, with rent owed through the departure date. When a domestic violence victim terminates under Section 24, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit must be returned within 30 days according to standard rules. Massachusetts' provision includes critical protections. The landlord must keep all documentation strictly confidential. The landlord cannot disclose the tenant's status as a victim. The landlord cannot use the domestic violence termination as a basis for negative references, future rental denial, or any adverse action. And the landlord cannot penalize remaining household members who were not the perpetrator. Tenants in Massachusetts may break a lease if the landlord fails to maintain habitable conditions. Massachusetts has one of the strongest implied warranties of habitability in the country, codified in Chapter 186, Section 14, and reinforced by the State Sanitary Code, 105 CMR 410. The landlord has extensive obligations to maintain the premises in a condition fit for human habitation. If the landlord fails to maintain the property and the failure materially affects health and safety, the tenant has multiple remedies. The tenant can withhold rent. Massachusetts is one of the few states that explicitly permits rent withholding for habitability violations. The tenant can repair and deduct, making repairs and deducting the cost from rent. And the tenant can terminate the lease if the conditions are serious enough. Massachusetts Board of Health can inspect properties and issue orders to correct violations. An official inspection report documenting housing code violations provides powerful evidence supporting a tenant's right to terminate. The tenant should request an inspection, obtain the report, and use it as documentation for the termination. The interaction between Chapter 93A and habitability is important. If the landlord's failure to maintain habitable conditions constitutes an unfair or deceptive practice, which Massachusetts courts have recognized in serious cases, the tenant can pursue 93A damages in addition to lease termination. The potential for treble damages under 93A creates a strong incentive for landlords to address habitability issues promptly. Boston's local ordinances add additional protections. Boston's Inspection Services, ISD, actively enforces the housing code. Landlords in Boston face more scrutiny than in many other Massachusetts communities, and tenants who terminate based on habitability have access to active city enforcement. From a practical standpoint, Massachusetts has a tight and expensive rental market, one of the most challenging in the country. Boston is the dominant market with extremely strong demand. When a tenant breaks a lease in Boston, the landlord can typically re-rent quickly, often within 2 to 4 weeks in desirable neighborhoods. The September 1st lease cycle dominates the Boston market. Most leases turn over on that date, and the peak rental season runs from April through September. A tenant who breaks a lease during peak season creates minimal vacancy. A winter lease break takes slightly longer to fill, but is still manageable in Boston's persistently tight market. The student population drives enormous seasonal demand. Breaking a lease in spring or early summer is absorbed rapidly as incoming students seek fall housing. Cambridge, Somerville, and Brookline have similarly tight conditions. Worcester has a growing market. Springfield is more affordable with moderate demand. Lowell, Lawrence, and New Bedford have diverse markets with varying demand levels. Cape Cod has seasonal dynamics. One critical best practice for Massachusetts landlords: never impose an early termination fee that could be challenged under Chapter 93A. The treble damages exposure makes aggressive fee provisions extremely risky. A fee of 1 month's rent with 30 days' notice is defensible. A fee of 3 or 4 months' rent invites a 93A claim that could cost you far more than the fee was worth. Another best practice: begin re-rental efforts immediately when a tenant provides notice. Massachusetts courts expect prompt, diligent mitigation. Document every step meticulously. In a state where the courts consistently favor tenants and where 93A provides treble damages for unfair practices, your documentation is your most important defense. A third best practice: address habitability complaints immediately and thoroughly. A tenant who terminates based on habitability, supported by a Board of Health inspection report, has an extremely strong legal position in Massachusetts. And the potential for 93A treble damages on top of lease termination makes habitability neglect one of the most expensive mistakes a Massachusetts landlord can make. Massachusetts limits the security deposit to 1 month's rent. The deposit must be held in a separate interest-bearing escrow account at a Massachusetts bank. The landlord must provide a receipt with the bank name, account number, and deposit amount. Interest must be paid annually. The deposit must be returned within 30 days of the tenant vacating. Failure to comply with any of the detailed deposit requirements can result in treble damages under 93A. These rules apply to broken leases and normal move-outs alike. For the complete guide to Massachusetts breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.